and therefore the judgment itself is also going to be almost a marathon, because a lot of aspects were dealt with, and even in this judgment, those aspects are going to be dealt with, and therefore the court will call on all of us to exercise patience. Thank you. Thank you. Before the court is an opposed bail application. The charges preferred by the state against the 6 applicants are as follows: murder, conspiracy to commit murder, attempted murder, and possession of unlicensed firearm. This application results under Schedule 6 as per the schedules in the Criminal Procedure Act 51 of 1977. Applicants being obliged to adduce evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit their release on bail. The applicants are as follows: Pakamani Vincent Hadebe, an adult male South African residing at number 106 Sheffield Street, Tarfontein, Johannesburg. Zita Hadebe, an adult South African male residing at number 27 Long Street in Captain Park. Pindandlovu, an adult South African male residing at number 32 Victoria Street, Rosettenville in Johannesburg. Sanel Mbele, an adult South African male residing at number 32 Victoria Street, Rosettenville, Johannesburg. Sipiwe Tabani Mazibuko, an adult South African male residing at number 74 Albert Street, Rosettenville, Johannesburg. Sipakanyiswa Dladla, an adult South African male residing at number 32 Victoria Street, Rosettenville, Johannesburg. The state is the respondent in this application. Through his affidavit, applicant 1 stated the following: that is a South African citizen, 29 years old, born in Win, KwaZulu-Natal. His village is in Mhlawe district, where there are no street names, no street numbers or house numbers. He has a common law wife who's unemployed and lives at the applicant's parental home at Mhlawe together with their 2 children. He does not have a passport and has never applied for one. He has not ever left South Africa. He has no friends or relatives who live beyond South African borders. He's a taxi patroller for the Captain Park Taxi Association, earning 5,000 rands per month. He has inherited 2 taxis from his late father, which taxis earn him a further monthly income of approximately 10,000 rands per month. He has no previous criminal convictions, no outstanding matters against him other than the one before court. Applicant denies that there is a warrant authorized against him on the 15th November 2019 in respect of murder and robbery matter being investigated under Police Case 5705/2019 in Escort. He denies any knowledge or involvement in such matters. Applicant 1 states that besides the alleged confession he made, the evidence that allegedly links him to the offenses preferred against him are barely circumstantial. He is innocent of the charges preferred against him. He has no knowledge and was not involved in the murder of Miss Babita Deokaran, nor any conspiracy to commit such murder. Applicant further states that he was arrested whilst driving a Volkswagen Polo, which Volkswagen Polo does not belong to him. The vehicle belongs to his friend, one Polani Dadla, and it is so that he, the applicant, used the vehicle occasionally. Applicant agrees that on the day of his arrest, he was in possession of a .45 pistol together with other personal items such as his driver's license and cash in the sum of approximately 1,300 rands, including 2 credit cards. His duly authorized license holder for the .45 pistol was arrested on Thursday, the 26th of August 2021 at around 7:30 p.m. at Spar Supermarket in Rosettenville by a sizable contingent of police personnel traveling in about 15 unmarked vehicles, all heavily armed and overly aggressive. Though not assaulted at the time of his arrest, he was manhandled with guns being pointed at him by the police, and this happening in full view of members of the public. He was taken to the Tarfontein race course. The Volkswagen Polo parked at what appeared to be an entrance to the race course. It was extremely quiet and secluded. He was removed from the vehicle, threatened by the police, and the police proceeded to assault him. His interrogators were accusing him of having killed someone in Mondia the Monday that had just passed. As he denied any involvement and knowledge of the persons involved, the blows and assaults continued. His hands had been handcuffed behind his back. He was extremely afraid. The questioning took the form: where is the car? Where are the guns? Where are your friends? The police accused him of not being one of the shooters, but that he had patrolled the area in and around the shooting. The police said that the information was that his co-applicants Zita, Latha, Ndlovu, Mbele, being the driver of the white BMW at the time of the shooting. Whilst not at the scene of the crime at the time it occurred, he was the one who organized the hit. When busy torturing him, the police said that the information was that he had received 400,000 rands for the hit. He was suffocated, a thick plastic being used to suffocate him. During the interrogation, he was shown photos of people he knew and whom the police alleged they were involved in the actual killing. A considerable part of the interrogation involved the accusation that they knew that our former health minister, Zweli Mkhize, had hired the applicant and others to kill Ms. Deokaran. At a point, this accusation included an allegation that Zweli Mkhize was accompanied by his brother. Applicant 1 says that he was not or had never met the health minister Zweli Mkhize, nor any brother of his. The applicant does not know Zweli Mkhize's siblings. Suffocation and torture were intense and painful. Eventually, to stop the torture and the death he believed would ensue. He admitted to the accusation that had been leveled against him, including that Zweli Mkhize and his brother had hired him and others to commit the murder. Applicant number 1 states that during his interrogation, by the nature of the questioning and accusations, he was given considerable specifics and details about the shooting. After his torture and his agreement to confess, he was taken to Kagiso police station, told that an officer would come to the station later to take his confession. At around 1 a.m. the next morning, another police officer came to the police cells and took the confession from him. Applicant 1 further states that the disclosure in the confession that he had met Zweli Mkhize and his brother at Brett's Mall was a complete figment of his imagination. He has not even visited Brett's, let alone Brett's Mall. Applicant challenges the state to produce video footage showing him visiting the mall, more particularly on the date on which he had visited the mall and met Zweli Mkhize, namely the afternoon of Monday, the 16th of August 2021. Applicant further states that he stated in his confession that he received 40,000 rands as his share and had deposited his entire share of 40,000 rands into his Nedbank account. The police have his bank credit card, the Nedbank one, and no doubt they've checked that this information is completely untrue. In these circumstances, the applicant submits that the state can hardly be said that it has a strong case against him. The applicant states that there's no evidence that hardly points at him as the perpetrator of violence. There's no evidence that he made any threat of violence to any person. He harbors no resentment or has no disposition to violence. There's no evidence that he had committed an offense referred to in Schedule 1. Applicant further states that he has no previous convictions. His emotional and occupational ties are both in Gauteng and KwaZulu-Natal. His taxi business is also in Gauteng. He's born and bred in South Africa. He has no passport to leave the country. Applicant submits that appropriate and proper bail conditions will allay fears that the state may have in regard to him being a flight risk. The strength of the state case can hardly be said that is an incentive that would attempt to evade his trial. The bail conditions prohibiting communication with any possible witnesses can effectively be enforced. Applicant will not conceal nor destroy evidence. He has not supplied any false information to the police. Applicant further submit that his release on bail will not undermine or jeopardize the public confidence in the criminal justice system. If he remains incarcerated, he will suffer not only financial loss, but also irreparable prejudice in him successfully prosecuting his defense. Applicant further states that prison conditions for awaiting trial inmates in Johannesburg prison are horrendous and in fact constitute gross violation of inmates' constitutional rights. There's overcrowding in cells, there's no hot water, even in winter, no adequate beds and blankets, pillows in the cells, ventilation is totally inadequate. Applicant could not properly consult with his legal representative. Applicant submits that being incarcerated until the matter is finalized will infringe on his rights to fair trial. Applicant further states that his right to legal representation was violated in that his legal representative was obstructed by the police to have access to him, but eventually his legal representative managed to have access to him, that is the client. This aspect will be fully dealt with in Mr. Sal's affidavit, that is the applicant's attorney. In conclusion, Applicant 1 prays that the court should grant him bail as requested, if need be, with any bail conditions, including, if need be, the most stringent of conditions until the matter is finalized. He is able to raise an amount of 10,000 rands for bail. Applicant number 2 stated the following in his affidavit: that he is a South African citizen, 29 years old, born in Winnen, KwaZulu-Natal, was born in a rural village. Though there are no street numbers or names, the postal code is 3325. He came to Gauteng about 4 years ago. He first resided at number 18 Pasco Avenue, Captain Park, and later moved to Long Street, number 27, Captain Park. Applicant number 2 denies that he stated to the investigating officer that he resides at number 32 Victoria Street, Rosettenville. Applicant states that he has a common law wife who is unemployed and lives at his parental home at Ntlawe District, Winnen, together with their 3 children. He is a manager of a car wash operated by the Captain Park taxi rank and earns an income of 4,000 rands per month. He also owns a taxi and he earns a further 8,000 rands per month. His wife is unemployed and he supports her and the children to the tune of about 5,000 rands per month. He assists the mother with about 1,500 rands per month. He has 1 previous conviction. In about 2011 at Winnen, he pleaded guilty to the charge of theft and was fined 2,000 rands or 6 months imprisonment. The state, in opposition to bail, has alleged that he is sought by the police in respect of Linden Police CAS 227 of 6 of 2015 and Captain Park CAS 366 of 6 of 2015. Applicant denies any knowledge and involvement in such matters. Applicant states that from the affidavit of the investigating officer, Captain Chauke, there is no evidence that links him to the commission of the offences being preferred against him. Applicant denies the veracity of the confession and further states that such confessions were elicited as a result of assault and torture, and that such confessions are in law not admissible against him. Applicant states that after his arrest, he was assaulted, punched, slapped, kicked in his lower body and stomach. He was accused of being involved in the murder of an Indian woman on Monday, the 23rd of August 2021, which accusation he persistently denies. At later stages, he was suffocated at Johannesburg Central Police Station with a plastic bag being placed over his face. On account of being killed, that is fear of being killed and pain resulting from his torture, he relented, agreed that he would make a pointing out and confess as his torturers demanded. However, he later proceeded to make a random pointing out to some police officer and was then driven to 1 or 2 other spots which appeared to be significant in the investigations. The only real evidence is that it is alleged that he was seen in possession of a white BMW with the same distinctive features to the one that was following the deceased and seen fleeing the vicinity of the crime scene. Applicant denies involvement in the shooting and any involvement or association with the white BMW in question. Over the years, he has driven many BMW motor vehicles, some which have been white in color. The white BMW referred to by the state is not conclusively identified as the vehicle used by the shooters. Applicant submits that the evidence that links him to the commission of the offense preferred against him is non-existent. It is common cause that he was arrested whilst visiting some of his friends at number 32 Victoria Street, Rosettenville, Johannesburg. As submitted earlier, such address was not his residence. The address recorded by the officer taking the point out, number 27 Long Street, Captain Park, is his address. The police, in a sizable contingent, barged into the house, not wearing uniforms or other identification to suggest that they were police officers, causing some pandemonium in the residence. You could see in the vicinity that others were immediately assaulted and accused of being involved in the killing of an Indian female person on the Monday that had passed. He was later taken to Johannesburg Central Police Station. Further assault and torture that he suffered at the hands of the police. He's not going to elaborate on given the lack of evidential material against him. The investigating officer contends that an unlicensed firearm was located at the premises, and he denies that he was in possession of such firearm as alleged by the state. Applicant submits that the state can hardly be said to have a strong case against him. The evidence hardly points to him as the perpetrator of a violent crime. The state's contention that himself and his co-applicants will easily repeat their conduct in respect of witnesses in the current matter is made without any foundation. He has one previous conviction and submits in the circumstances that his previous conviction does not point to a propensity to commit Schedule 1 offenses. Applicant submits that his emotional and occupational ties are both in Gauteng and KwaZulu-Natal. His taxi business is also in Gauteng, and is born and bred in South Africa. There is no prospect of him leaving South Africa. Proper and appropriate bail conditions will allay fears the state may have in regard to him being a flight risk. Applicant will not intimidate witnesses or destroy evidence. He will not evade trial. Applicant states that if he is incarcerated, he will not only suffer considerable financial loss, but preparing for trial will clearly, irreparably prejudice him in successfully prosecuting his defense. Applicant reiterates that he has no desire to flee from the police nor evade his trial. Applicant states further that the conditions for awaiting trial inmates at Johannesburg prison are horrendous and in fact constitute a gross violation of inmates' constitutional rights. Insofar as legal visits are concerned, Only non-contact visits are allowed with legal representatives once per week on Friday from 10 to 1400 hours. Applicant submits that with consultation conditions being unfavorable, being incarcerated until the matter is finalized would infringe his right to fair trial, in that he will not be able to properly consult with his legal representative to properly prepare for trial. In conclusion, applicant states that he can afford an amount of 10,000 rands for bail. He is willing to submit himself to any bail conditions that the court deems prudent and appropriate to impose. If need be, the court may even subject him to house arrest. There's no reason for him to abscond. He will stand trial. Applicant humbly requests the court to grant him bail, if need be, coupled with the most stringent of conditions until the matter is finalized. Applicant number 3, Pindan Ndlovu, stated the following in his affidavit: that he is a South African citizen, 26-year-old, and was born in East Court at rural district of Mchezi in Winan, KwaZulu-Natal, and has lived there for most of his life. He came to Gauteng about 3 years ago, and after living with friends in various places, he eventually rented a residence at number 27 Khyber Street, Captain Park, where he lived for about 2 years, and then went to live with his uncle at Ivory Park Extension 2 in Tembisa. He has a daughter, aged about a year, living with a mom in Colenso, Pietermaritzburg. His mother lives in Pietermaritzburg, and his father lives at JP Hostel. He and his mother are unmarried. That is the father. He has no friends or relatives outside South Africa. He is employed as a taxi patroller for the Captain Park Taxi Association, earning 2,400 rands per month. He supports his baby to the tune of 400 rands per month and a few hundred rands towards his mom. He has no previous criminal convictions. He knows about the 2 matters pending against him. He was arrested for possession of an unlicensed firearm and granted bail of 2,000 rands. His brother said to him he would clear the matter with the police and that it is not necessary to appear in court on the 26th of February 2021, since the charges were to be withdrawn. He has been advised that his reliance on his brother was foolish. Applicant further states that he was arrested in May 2021, arrested for possession of a unlicensed firearm, which firearm was found in a motor vehicle wherein he got a lift. He was released on warning at Wynberg Regional Court. His legal aid attorney, whose name he cannot recall, informed him that without a doubt the charge against him will later be withdrawn. He was warned to appear in the Regional Court, Wynberg, on the 15th June 2021. Regrettably, just before his court appearance, his uncle died. He was distraught at his sudden death. He returned to KwaZulu-Natal for funeral arrangements for his uncle. Applicant did not attend court in June 2021. He attended Wynberg Court shortly after his return in late July to early August 2021, and court security did not allow any access due to COVID-19 problems in the building. He continued to attempt to contact his legal aid attorney without any success until the time that he was arrested. Applicant states that he was not evading the charges against him in such court. Applicant further states that the state, in its opposition to bail, also alleged that it is sought by the police in respect of Muden Police Cast 50/11 of 2019 and Colenso Police Cast 38/12 of 2020. Applicant denies knowledge or involvement in these matters. Applicant states that the only alleged evidence linking him to the commission of the offense is a purported pointing out he made to the police, which pointing out he believes is not linking him to the commission of the offenses being preferred against him. He is innocent of the charges being preferred against him. He has no knowledge and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to commit such murder. It is common cause that the applicant was arrested with some of his co-applicants at the residence at number 32 Victoria Road, Rosettenville, Johannesburg. The night of their arrest, many heavily armed officers barged into the residence, pointing their firearms at them, never identified themselves as policemen. He was immediately assaulted, a gun put in his mouth, and the person with the gun threatened that he was going to kill him. At some point, he realized that they were police officers. They were accusing him of shooting an Indian woman on the 23rd of August 2021 at or near Mondia. The police, in demanding to know why did he kill the woman, who hired him to do so. He continued to deny any involvement in the murder, and the police continued to punch, kick him, and threaten him. Applicant states that he was detained at Johannesburg Central Police Station for the night, and the following morning, his interrogation and assault continued. The accusations leveled against him were repeated with further allegations that such woman was driving a Mercedes-Benz. Eventually, in pain, completely exhausted, and with fear that the police threats to kill him would be realized, applicant relented and agreed to all the accusations leveled against him. Applicant was asked to make a written statement. He stated that he needs a lawyer, but informed that he will get a lawyer later. Applicant made his confession to the police. He later was threatened and he cooperated in making point outs. He has been advised that there is no evidence against him linking him to the commission of the offences in question. The state can hardly be said to have a strong case against him. There is no evidence that he had previously committed an offence referred to in Schedule 1. He has no previous criminal convictions. Applicant submit that his emotional and occupational ties are both Gauteng and KwaZulu-Natal. He was born and bred in South Africa. He has no passport to leave the country. There is no prospect of him ever leaving the Republic of South Africa. Applicant state that he will not threaten or intimidate witnesses. His release on bail will not jeopardize or undermine the public confidence in the criminal justice system. If he remains incarcerated, he will suffer not only considerable financial loss, but preparing for trial will clearly irreparably prejudice him in the successful prosecution of his defense. Taking into account difficult conditions insofar as access to legal representation and consultation is concerned. Applicant also states that the prison conditions for awaiting trial prisoners at Johannesburg prison are horrendous and constitute a violation of inmates' constitutional rights. In conclusion, applicant submits that to allay fears that the state may have, the court may impose suitable bail conditions, and it can afford to raise an amount of approximately 10,000 rands for bail. Applicant humbly requests to be released on bail with stringent conditions if need be. Applicant number 4, Sanel Mbele, stated the following in his affidavit: that he is a South African. He resides at number 32 Victoria Street, Procedural, Johannesburg. His address has been confirmed by the investigating officer. He is 27 years old, was born in Winnen, KwaZulu-Natal. He spent most of his early years and teenage years in Winnen. He is unmarried and has no children. His parents are divorced. He has no passport and he has never applied for one. He has no friends or relatives outside South Africa. He has never left the Republic of South Africa. He is employed as a taxi patroller for the Annandale Taxi Association and earns a weekly salary of 1,500 rands. He has no other source of income. He has no previous convictions and no matters pending or outstanding against him. He was previously charged with fraud. He was released on bail and he attended this matter until the matter was finally withdrawn. Applicant states that the allegations on the part of the state that incriminates him in the commission of the offense is that he made a point out and confession regarding his involvement in the murder. Applicant states that he is innocent of the charges preferred against him. He has no knowledge and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to commit such murder. It is common cause that he was arrested at his residence at number 32 Victoria Street, Rosettenville, Johannesburg. The police, in a sizable contingent, barged into the house, not wearing any uniforms or other identification to suggest that they are police officers. They were assaulted and accused of being involved in the killing of an Indian female person the Monday that had passed. During the assault, some of the blows connected with his face, and as a result, he sustained a cut on the lip and a broken tooth. After his arrest, he was taken to Johannesburg Central Police Station. The state alleges that he was found in possession of a firearm. However, he denies possession of such. At Johannesburg Central Police Station, he was questioned and accused of being involved in the murder. He denied any involvement. He was told that his friends have admitted their involvement, and if he was not going to do so likewise, they were going to torture and, if need be, kill him. He denied knowledge and involvement in the commission of the offense. The following morning, the threats continued, but he was never assaulted. Applicant states that he informed the police that he wishes to contact his family. He complained that he was not allowed to phone since his arrest. he wants to request his family to arrange for a lawyer to come and see him. During his earlier interrogation, the applicant was told by the police that they know that he was the driver of the vehicle that was used by the shooters in the commission of the murder. With such information, the applicant continued with the pointing out. As regards the place where the shooting took place, he took the police officer to Mondia, and due to his inability to precisely show where the shooting occurred, he was taken to a place by the officer where he gathered that the shooting had occurred. He is advised by his legal representative that his right to remain silent and to have access to legal representation was violated, and that it would be argued that, notwithstanding the customary approach by a bail court, that the admissibility or otherwise or point out and confession is usually a consideration left for the trial court. The palpable irregularities in taking of his point out, namely the applicant, will and should invite an incur from even a bail court, and such unlawful conduct on the part of the police should occasion a finding that such point out will be inadmissible at trial. In the circumstances, the applicant submits that the state can hardly be said to have a strong case against him. There is no evidence that points to him as a perpetrator of a violent offense. It can hardly be said that there is a disposition on his part to commit offenses referred to in Schedule 1. Applicant submits that his emotional and occupational ties are both in Gauteng and KwaZulu-Natal. He was born and bred in South Africa, does not have a passport to leave the country. There are no prospects whatsoever of him ever leaving the Republic of South Africa. He will not intimidate or influence witnesses. If he remains incarcerated, he will suffer not only considerable financial loss, but preparing for trial with access to legal representation and other hardships in prison will certainly do irreparable prejudice in him successfully prosecuting his defense. He is not a flight risk. Applicant states that prison conditions for awaiting trial inmates at Johannesburg prison are horrendous and in fact constitute a gross violation of inmates' constitutional rights. Also could not properly consult with his legal representative, Mr. Saleh. In conclusion, applicant requests to be released on bail, can afford an amount of 10,000 rands with bail conditions, and he will comply to such. Applicant number 5. Spiwe Tabane Mazibuko stated the following in his affidavit. That is a South African. He resides at number 74, Albert Street, Rosettenville, Johannesburg. He lives with his grandmother, and the home is owned by her. He has been living there for over 6 years. Applicant states that he is 28 years old, was born in Mutu, KwaZulu-Natal. He passed matric in 2011 and in 2013 enrolled at Central Johannesburg College for a 3-year course in electrical engineering. He completed the course in 2016. His mother died in 2007. He has a daughter of 6 years old who lives in Sunrise in Mutu, KwaZulu-Natal with a maternal grandmother. He is a South African, born and bred in this country. He does not have a passport and has not applied for one. He has never left the Republic of South Africa. He has no friends or relatives who live beyond the borders of our country. Applicant is a registered Bolt taxi driver. He earns approximately 10,000 rands per month. He supports his daughter to the tune of approximately 1,500 rands per month. He also assists his grandmother with about 30,000 rands per month, which includes his contribution for living at her home. The applicant has no previous convictions. There's no pending matters against him other than the one before court. He believes that in his opposition to his release on bail, the state contends that the evidence that incriminates him in the commission of the offense is that of 2 photographs of the residential complex where the deceased resided. He saved in his mobile phone, and that the deceased motor vehicle appeared in one of these photos. Further, that after his arrest, he confessed. Applicant respectfully submits that the evidence that links him to the commission of the offense or offenses preferred against him is barely circumstantial. Applicant says that he is innocent of the charges preferred against him. He has no knowledge of and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to murder. In regard to the photos on his mobile phone, which are as or ostensibly that of the complex where the deceased resided, applicant confirms that as a bold driver, the history of his rides will confirm that he often works in the Johannesburg South area, including Mondio. At some point during his travels in the area, he had taken photos of various complexes, in that he was planning to rent a flat or townhouse in the area to take up such residence in a unit with a girlfriend. It may be that the 2 such photos are that of the deceased residence and that the deceased motor vehicle appears in one such photo. Applicant denies that the photos were taken for any nefarious purpose. Furthermore, at the time of taking such photos, he was not aware that the said motor vehicle belonged to the deceased. Applicant states that it is correct that he was arrested on the night of the 26th of August 2021, was driving his Volkswagen Polo with registration numbers and letters HV49KJGP. He was with a friend, Onke. They were at Shell filling station, filling in some petrol. Suddenly, an unmarked vehicle pulled up on the forecourt of the filling station, blocking his path, and around 3 occupants jumped out, pointing guns at Onke, and he was ordered, together with Onke, to climb out of the vehicle. He believed that they were about to be robbed. He tried to run, but a second vehicle blocked his path. He was apprehended. Onke and himself were bundled into separate vehicles and taken to Tarfontein Racecourse, where each of them were removed from separate vehicles and made to lie face down on the ground, both handcuffed behind their backs. At that point, given the accusations held at him by their abductors, he realized that they were in fact police officers. And later, some police officers in uniform arrived. They were being accused of having killed someone. A policeman who was principally involved in his interrogation consistently threatened that he was going to kill him, pointing his firearm at him. At some point, he was threatened that he was going to be taken to a dam to swim. Though he was threatened, and manhandled. At that stage, he was not really assaulted. He was then taken to a home in Victoria Street, Rosettenville, where some of other suspects who are his co-applicants were arrested. There again, he was interrogated and accused of being involved in the murder of an Indian woman earlier that week. The interrogation by the three officers also included assaults. He was accused of being the mastermind of what appeared to be a contract killing. The allegation being that they were paid a sum of 400,000 rands. He was told that his accomplices have confessed and that he should also confess and reveal where the money was, where the guns were, and who hired him. Later, he was interrogated by the investigating officer, Captain Chauke himself, who threatened him that he will be assaulted and killed if he does not confess. Applicant then falsely confessed to his involvement. Captain Chauke proceeded to read from some documents what the applicant and others had purportedly done. He simply confirmed it to be correct. Applicant finally consulted with his attorney, Mr. Sally, during the afternoon of Saturday, the 28th of August 2021. He conveyed to Mr. Sally that he had been assaulted, threatened, etc. His attorney informed him of his rights, including also a right to remain silent. In the circumstances, applicant humbly submit that the state can hardly be said to have a strong case against him. It can hardly be said that there is a disposition on his part to commit offences referred to in Schedule 1. There is also no evidence that the applicant had previously committed an offence referred to in Schedule 1. Applicant submit that his emotional and professional ties are in Gauteng. He was born and bred in this country. His family is historically tied to KwaZulu-Natal rural community. He has no passport to leave the country. There are no prospects of him leaving the country. He will not threaten or intimidate witnesses. Applicant states that his release on bail will not undermine or jeopardize the public confidence in the criminal justice system. In conclusion, applicant submits that to allay any fears that the state may have, the court may impose suitable bail conditions, can raise an amount of 10,000 rands for bail, and applicant requests to be released on bail. Applicant number 6, Sipakanyiswa Dladla, stated the following in his affidavit: that he is a South African, resides at number 32 Victoria Street, Rosettenville, Johannesburg. At the time of his arrest, he had lived at the said residence for about 5 months, and he previously lived at number 13 Arrow Street, Captain Pike, where he resided for 2 years. He's 25 years old, was born in Winnen, KwaZulu-Natal. He spent most of his teenage years in his village in Hlawe district, where there are no streets, no street numbers. He's unmarried. His mother is a pensioner. His father is deceased. He's born and bred in South Africa. He has no passport and has not applied for one. He's never left the Republic of South Africa. He has no friends, no relatives who live beyond our country's borders. Applicant is a taxi patroller with Captain Park Taxi Association, earns approximately 3,200 rands per month, and from his taxi he earns approximately 10,000 rands per month. He does not have children, but supports his mother to the tune of 3,000 rands per month. He has no previous criminal convictions, no outstanding matters against him, was never arrested before. The state, in its opposition, has produced an application for a warrant of his arrest authorized on the 2nd of September 2021 after his arrest on this matter. Applicant denies knowledge or involvement in such matter. Applicant submits that the consideration of the allegations on the part of the state that incriminate him in the commission of the offences being preferred against him is based on a single allegation that he made a bond out and confession in respect of his involvement in the murder of the deceased. He is innocent of the charges being preferred against him. He has no knowledge and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to commit such murder. It is common cause that he was arrested whilst at his residence at number 32 Victoria Street, South Johannesburg, at the same time as several of his co-applicants were also arrested. Applicant was assaulted. There were about 20 police officers. He was accused of being involved in the recent murder of an Indian woman at Mondio, which accusation he persistently denied. The interrogation and assault continued at Johannesburg Central Police Station. He was assaulted, threatened that he would be killed. He was terrified that he would be killed, and eventually, to stop the beatings, he said that he would confess. He was informed that his confession would be taken by a senior police officer. An hour or so after his warning statement, he was taken to a different building in the Johannesburg CBD, where he met a senior officer who proceeded to take his formal confession, and later pointing outs were done. At some point, he asked if he could have a lawyer, but was told that he would have a lawyer later. Applicant states that the confession and pointing out he did were done as a result of him being forced and were obtained under duress. Applicant submits that the state can hardly be said to have a strong case against him. He has no previous convictions. He submits that his emotional and occupational ties are both in Gauteng and KwaZulu-Natal. His taxi business is also in Gauteng. He was born and bred in this country. His family is historically and presently tied to the KwaZulu-Natal rural community. He has no passport. There is no prospects of him leaving the country. He will not threaten or intimidate the witnesses. His release will not undermine or jeopardize the public confidence in the criminal justice system. If he remains incarcerated, it is clear that he will not only suffer considerable financial loss, but preparing for trial will clearly irreparably prejudice him in the successful prosecution of his defense. He is not a flight risk. Applicant states that the prison conditions for awaiting trial inmates at Johannesburg prison are horrendous and in fact constitute a gross violation of inmates' constitutional rights. In conclusion, applicant requests the court to release him on bail with suitable conditions and is able to raise an amount of 10,000 rands bail. The attorney of the applicant, Mr. Sali, made a confirmatory affidavit wherein he states that he's an adult male attorney, duly admitted and practicing as such, and that he's a senior partner at Sali and Ishmael Incorporated in Johannesburg. He confirms that the afternoon of the Friday, the 29th of August 2021, at approximately 3 to 4 p.m., he received instructions to urgently represent 7 applicants, including Onke, who had been arrested earlier that day or the night before on charges relating to the recent murder, namely on the 23rd of August 2021 of the Chief Director of Financial Accounting in the Department of Health, and which killing had received widespread media attention. Having learned that the applicants or his clients had been arrested in the Rosettenville areas and that the offense had been committed within the Mondio district, he set about, together with his staff, including the assistant attorney employed at their firm, that is Tian Peters, and his secretary, Adrian John, to call various police stations in the area of Mondia and Boisens to ascertain whether the applicants were detained at police stations in such areas. Despite numerous calls, including to Johannesburg Central Police Station, they could not trace the whereabouts of the applicants. Several officers were phoned in trying to locate the applicants with no success. Mr. Sali also states that to assist him in the tracing of the applicants, he briefed Advocate Wilkins, who, from periodical reports, was equally unsuccessful in tracing the whereabouts of the clients. By the morning of Saturday, the 30th August 2021, he had not been able to trace the applicants. And this prompted him to discuss with Advocate Wilkins the possibility of bringing an urgent application against the Special Unit and the Minister of Police to force them to disclose the whereabouts of the applicants, and of course to allow him access to his clients. The same morning of the 30th of August 2021, he finally received information from a source that 7 clients were being detained at Johannesburg Central Police Station. He eventually decided to attend personally at Johannesburg Central Police Station, where he, after a lot of challenges and frustrations, eventually located his clients at the police station. Each of the clients, excluding Onke, complained that they had been assaulted. Mr. Sali also confirms and corroborates the contentions and assertions made by the applicants in the affidavits in support of their release on bail, insofar as same relates to him. More particularly, the assertions dealing with the challenges faced in proper legal visits at Johannesburg prison. Mr. Shafiq Sali, applicant's legal representative, made a supplementary affidavit and stated the following: that in proper fulfillment of his mandate and duty to the applicants, he had considered obtaining an appropriate affidavit from our former Minister of Health, Zweli Mkhize, of course, with the prior consent of the state. It is common cause that in response to their request to engage with Zweli Mkhize's attorneys, the state placed on record during bail proceedings on Friday, the 5th of November 2021, that Zweli Mkhize was considered a potential state witness or suspect in the investigations. Consequently, they are unable to solicit any comment from Zweli Mkhize. regarding his incrimination by the first applicant in his confession. That now forms part of the record of the bail proceedings. However, Mr. Sali believes that it is in the interest of justice and this bail court be seized with all the relevant information and facts of the matter, that it be disclosed that Zweli Mkhize has widely circulated media reports, in fact responded to the said allegations that have been made against him in the said confession. Mr. Sali believes it's salient to record one such report by the Daily Maverick, wherein inter alia it is stated, a statement from Mkhize released on Wednesday said that it was with shock and sadness that he learned that his name had been dragged into the case. The men arrested in connection with Deokaran's murder. Mkhize would like to take this opportunity to assure the Deokaran family and all South Africans who are still reeling from the trauma of this scaleless crime that he had absolutely nothing to do with it, nor the alleged procurement irregularities which are believed to have driven it. The statement reads, it should be remembered that these alleged procurements irregularities took place at the provincial level, far away from the national sphere of government where he was deployed as the National Minister of Health. Respectfully, the unequivocal denial by Zweli Mkhize of the contents of the confession by the first applicant in connection with Zweli Mkhize's involvement in the crime, together with at least explanation as to the improbability of his connection with the offense, offers further basis for a finding, even at this early stage, and moreover, at the hearing of this bail application, that the confession of the first applicant, and at least in its material respect, is palpably false. This court will deal with this aspect at a later stage. The state, through the affidavit of one Percy Chauke, responded as follows. That is an adult male South African employed by the South African Police Service, holding the rank of a captain, stationed at Central Johannesburg Central Serious Organized Crime Unit. He is the lead investigating officer of Mundia Cas 369 of 8 of 2021, which relates to the current application before court. The investigating officer states the following: further, that applicant number 1, Phakamani Hadebe, was arrested on the 26th of August 2021 at approximately 1940 hours in Rosettenville, whilst driving and being the only occupant of a Volkswagen Polo with registration numbers CV 82BJ GP, which vehicle was used in the planning and execution of the murder. Phakamani Hadebe, shortly after his arrest, made a confession in respect of the events on the 23rd of August 2021, as well as the days leading up to the incident. to the Justice of Peace, a captain in the SAPS, which included details of all his co-accused, as well as the identity of the persons who ordered the murder of the deceased. Phakamani Hadebe provided a residential address of number 106 Sheffield Street, Rosettenville. Prior to residing in Rosettenville for a month, he comes from KwaZulu-Natal from an unknown address. A J50 warrant of arrest has been authorized for Phakamani Hadebe in respect of escort CAS 5705 of 2019 relating to charges of murder and robbery. Applicant number 2, Zita Hadebe. On the evening of the 26th of August 2021, members of the SAPS acting on the information they have received attended the residential premises of number 32 Victoria Street in Rosettenville. At this residential address, they found the third, fourth, and sixth applicants inside the room. The third applicant was arrested inside the room, whilst the fourth and the sixth applicants ran into a bathroom where they were arrested. An unlicensed firearm was located at the premises, which, along with DNA samples taken from all the suspects or the applicants, is being subjected to DNA analysis to ascertain who all possessed the firearm. On the afternoon of the 23rd of August 2021, in Captain Park, Zita Hadebe, along with the suspect yet to be arrested, was seen in possession of a white BMW with the same distinctive features that was seen following the deceased vehicle, as seen fleeing the vicinity of the scene of the offense. Zita Hadebe, together with Lovu, Mbele, and Ladla, gave their residential addresses as number 32 Victoria Street, Rosettenville. The address verified with one Mrs. Unke, who did indicate that all four applicants have resided at the premises for only 3 weeks prior to their arrest. Zita Hadebe, prior to the 3 weeks resident in Rosettenville, comes from KwaZulu-Natal from an unknown address. Zita Hadebe is also sought by the police in respect of Linden, CAS 227 of 6/2015, and Captain Park, CAS 366 of 6 of 2015. Applicant number 3, Pindandlovu, was arrested at number 32 Victoria Street, Rosettenville on the 26th of August 2021. After his arrest, Pindandlovu made a pointing out to Lieutenant Colonel of the SAPS, wherein he admitted his involvement in the murder. The residential address he provided, number 32 Victoria Street, was occupied by him and others for 3 weeks prior to their arrest. Before the 3 weeks period, he came from KwaZulu-Natal from an unknown address. A bench warrant of arrest was issued for Pindandlovu 15th of June 2021 at the Alexandra Regional Court for failure to appear before court in respect of Regional Court 310 of 2021, which relates to a charge of possession of an unlicensed firearm. Applicant 4, Sanele Mbele, was arrested in the bathroom at 32 Victoria Street, Rosettenville, on the evening of the 26th of August 2021. He later made a pointing out and confession regarding his involvement in the murder, provided his residential address as 32 Victoria Road, Rosettenville, A residential address he occupied for 3 weeks prior to his arrest. Stanley Mbele comes from KwaZulu-Natal from an unknown address. Applicant number 5, Siphiwe Mazibuko, was arrested on the 26th of August 2021 at approximately 20:45 hours whilst driving his Volkswagen Polo with registration numbers HV49JKGP. It has been established that the photo of the residential complex that the deceased resided at was saved on his mobile phone. Upon his arrest and having been warned of his rights, Siphiwe Mazibuko confessed of his involvement in the offense. However, at a later stage, when formally booked out to have his statement reduced to write, he stated that he had consulted an attorney who told him not to say anything further. Applicant number 6, Siphiwe Dladla, was arrested on the evening of the 26th of August 2021 at number 32 Victoria Street, Rosettenville. After his arrest, Siphiwe Dladla made a point out and confessed in respect of his involvement with the murder of the deceased. A J50 warrant of arrest was issued for Siphiwe Dladla in respect of a murder and robbery that occurred on the 11th of May 2019 in Estcourt. He gave his address as number 23 Victoria Street, Rosettenville, an address he occupied for 3 weeks prior to his arrest. He comes from KwaZulu-Natal from an unknown address. Applicants 1 to 6, legal representative address the court as follows: that the state intends to prosecute all the applicants with the offenses contained in Schedule 6 of Act 51 of 1977. It follows that the provisions of Section 60 sub 11 subsection A of the Act are applicable. It is trite that the applicants carry the burden of satisfying the court on the balance of probabilities that exceptional circumstances exist which in the interest of justice permit their release on bail. The court is asked to take into account the following general principles applicable to bail applications in mind: the right to legal representation being the backbone of our legal system for a very long time. That in Brink versus Commissioner of Police, 1960, Volume 3, SA, page 65, a Transvaal decision, at paragraph 67B to C and 68A to 69H. The court stated that it is a fundamental right of every South African citizen, upon apprehension or arrest, to obtain legal advice and to consult with his or her legal advisors. The right has now been constitutionally entrenched in terms of Section 35(2) sub B of the Constitution of the Republic. Everyone who is detained, including a sentenced prisoner, has the right to choose and to consult with a legal practitioner and to be informed of his rights promptly. An accused, in the absence of a conviction by the court of law, is constitutionally presumed to be innocent. in S versus Atchison, 1991, Volume 2, SA 805. It's a Namibian court decision at page 822. A to B, Mohammed J. emphasized that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused unless this is likely to prejudice the ends of justice. In State versus Jonas, 1998-2, South African Criminal Report 677 SEC, Horan J. inter alia remarked as follows: it could not have been the intention of the legislature when it amended the Act by introducing Section 60 sub 11A to legitimize the random incarceration of persons who are suspected of having committed Schedule 6 offenses. Such persons must, after all, be regarded as innocent until proven guilty in a court of law. The introduction of Section 60 sub 11A was intended to make the obtaining of bail by accused persons who are charged with certain serious offenses more difficult, but not impossible. The applicants submit that, notwithstanding uncomplicated dictionary meaning of exceptional circumstances, it has proved to be an elusive concept. In the main, the applicant's legal representative, as per the heads of argument, submit that the state cannot link the applicants to the charges preferred against them. Only through forced confessions and point outs is the state alleging that the applicants are linked to the offense. That the applicant's right to legal representation and access thereto was infringed deliberately by the police officers, inclusive of the investigating officer. That this bail court has to pronounce that the confessions and point outs obtained by force or assault to the applicants will at trial not be admissible. Furthermore, that applicant number 1 cannot be linked to the firearm, was not found in possession. This weakens the state's case. Exceptional circumstances exist. Applicant number 2 was seen driving the BMW motor vehicle. The BMW motor vehicle was not found. This does not take the state case further. Second applicant never took the police to where the offense was committed, the scene where the deceased was shot. Nothing was said by the applicant during the point out. Confession was made by the co-accused. There is no evidence against the second applicant. The state case is non-existent against him. For applicant number 3, the state relies on inadmissible evidence. Investigating team did not respect applicant number 3's right to access or right to legal representation. Applicant taken to do point outs by officers knowing that Mr. Sali, his legal representative, is available. State case is non-existent against accused or applicant number 3. In respect of applicant number 4, the identification given by the police officer gives very little information. The BMW motor vehicle was never found. It seems that it cannot be found. There's no strong case against applicant number 4. Applicant requested the police to contact family, but never given an opportunity. Was assaulted, broken tooth, cut on the lip, and was bleeding. The investigating officer, Mr. Chauke, denied legal access to applicant number 4. State case is extremely weak against him. In respect of number 5, is linked through photos found in his phone. Photos were taken because he was considering to buy a townhouse in the area. Confession against applicant number 5 is inadmissible. State case is weak against him. In respect of applicant number 6, applicant number 6 was assaulted, tortured by the police. They point out confession made by him is inadmissible. State case is also weak against applicant number 6. In conclusion, applicants state that they have discharged the onus on them. They've proven that exceptional circumstances exist which in the interest of justice permit their release on bail, and consequently request that the court should release all of them on bail. The state addressed the court in the following: the strength of the state case or the lack thereof, and prior addressing the attack by the applicants on the strength of the state case, the state respectfully submitted that the following principles should be kept in mind. Section 60, sub 11bc of the Criminal Procedure Act provides the record of bail proceedings, excluding the information in paragraph A, shall form part of the record of the trial of the accused following upon such bail proceedings, provided that if the accused elects to testify during the course of the bail proceeding, the court must inform him or her of the fact that anything he or she says may be used against him or her at his or a trial, and such evidence becomes admissible in any subsequent proceedings. Applicants, as indicated, submitted affidavits as alternative to viva voce evidence. The remarks of Homo J in S versus Agliotti, 2012-1, SACR 559, GSJ, at paragraph 39 are worth repeating. It is my considered view that even where an accused and an applicant in the bail hearing concerning Schedule 6 offences intends to use an affidavit, it is peremptory duty of the court, right at the beginning of the proceeding, to warn him fully and comprehensively of the provisions of Section 60, sub 11bc, that would allow the applicant or an accused to make an informed choice before he decides to testify before voce or making use of an affidavit. It does not make sense to me to want to utilize evidence obtained through both oral testimony and affidavit, but accept the owner of such evidence to be warned only when he testified orally. As stated before, both oral evidence and affidavit are evidence that may be used in subsequent trial. As such, the requisite warning should be issued by the court to the accused before he or she elects to orally to use an affidavit. If he has been properly warned, then those bail proceedings should be admissible in his subsequent trial. The applicants were fully and comprehensively warned by the Honorable Court at the commencement of their application, and all evidence presented by them during their application for release will be admissible against them at subsequent trial. The applicants all raised similar issues regarding the admissibility of the separate statement due to non-compliance with the relevant sections of the Criminal Procedure Act, as well as alleged refusal to consult a legal representative. It is, however, necessary to highlight certain aspects of each applicant's version separately. The first applicant's affidavit, as per paragraph 42, contained at page 122 of the bundle, reads, "I then proceeded to narrate what I expected from my torturers wanted of me, some of the content I had gleaned from the lengthy interrogation of me." The second applicant states, as per paragraph 25 of the affidavit contained at page 182 of the bundle, "I later proceeded to make a random pointing out to some police officer and was then also driven to two spots which appeared to be of significance in the investigations." The fourth applicant states in paragraph 36 of his affidavit contained at page 284 of the bundle, "I'd simply taken the officer to Mondio, whereafter, given my inability to precisely show where the shooting occurred, I don't manage to glean this from the accusations leveled against me during my interrogation. I was taken to a place by the officer where I gathered the shooting occurred." The sixth applicant states in paragraph 31, 32 of his affidavit contained page 375 of the bundle, "I was taken by the captain to a complex where photos were taken of me. For the road trip, I proceeded to then again convey to Captain Madibo much of the information I had gleaned from the earlier interrogation. Although further and full argument will be made in relevant time of trial, it is at this stage suffice to say first, second, fourth and sixth applicants on their own versions are not the authors of their confessions or admissions made by the conduct. As such, the issues related to their respective statements deal with credibility and not admissibility thereof. Even if the trial court rules that the issues raised by the applicants amount to a question of admissibility by way of trial within the trial, the state would be entitled to confront the applicants with the content thereof during the trial within the trial. The remarks by Boschers J. in Esses versus Marke, 2001-2 SACR 28W 289J 290B highlights as much. State versus Gaba 1985 4 SA 734A. It also held that it was irregular for a trial judge to ask a witness to read out the contents of a confession during a trial within a trial before a ruling had been made on its admissibility or inadmissibility. An exception is made to the general rule where an accused alleges that and were not within the accused's own knowledge. In contrast, the third applicant states in paragraph 32 of his affidavit contained at page 28 of the bundle, "Under these circumstances, I then proceeded to do the pointing out." It is clear that although the admissibility thereof may have to be determined by the trial court, the author of the admissions by conduct was the third applicant, and the information contained therein was not provided to him by the police. This on its own proves a prima facie case against the third applicant. As per the supplementary affidavit of Captain Chauke, the relevant witnesses, including Captain Chauke, dispute the allegations made against them by the applicants. It is further respectfully submitted that the comments of Herr J.A. in S versus Matibula 2010-1 SACR 55 Supreme Court of Appeal at paragraph 12 are significant. In order successfully to challenge the merits of such a case in bail proceedings, an applicant needs further to prove, or he must prove, on the balance of probability that he will be acquitted of the charges. But the state is not obliged to show its hand in advance, at least not before the time when contents of the docket must be made available to the defense. Nor is an attack on the prosecution's case at all necessary to discharge the onus. The applicant who chooses to follow that route must make his own way and not expect to have it cleared before him. Thus, it has been held that in an application, until an applicant has set up a prima facie case of the prosecution, failing, there's no call on the state to rebut his evidence to that effect. It is respectfully submitted that the mere fact that the applicants intend challenging the admissibility of this statement does not meet the threshold set in State versus Matibula above. The issue of admissibility and or credibility of statements will be decided by the trial court, having considered the credibility and reliability of the witnesses in the matter, as well as the probabilities and improbabilities in the evidence. Such evidence is not before this honorable court, and a determination of admissibility is not currently possible, nor is it required. The applicants have elected to present the confessions and admissions by conduct, established that the state factually has a prima facie case against them. Further, the state will at the time of the trial argue that the first and the sixth applicants have, to their benefit, directly referred to their confessions. The first and the sixth applicants' confession, regardless of the aforementioned issues related to credibility versus admissibility thereof, and therefore admissible against them in terms of Section 2173 of the Criminal Procedure Act. The affidavits of Captain Chauke highlights that there is additional circumstantial evidence creating a prima facie case against the applicants. It is proper for a court to convict an accused on circumstantial evidence, provided it has the necessary probative force to warrant conviction. This, as stated in S versus Mpuna, 2012-1, South African Criminal Law Reports at 167B at 170A. The evaluation of circumstantial evidence must be guided by a test of reasonableness. The onus on the state is not that it must prove its case with absolute certainty or beyond any shadow of a doubt. All that is required is such evidence as to satisfy the court and prove its case beyond reasonable doubt. In respect of circumstantial evidence, the following requirement must be met. The inference sought to be drawn must be consistent with all proven facts. The proved facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. What is clear from the above is that a determination in respect of the circumstantial evidence will only be possible after the trial court has heard all the evidence. The applicants merely referring to the state case as barely circumstantial no way proves that the applicants will be acquitted of the charges. It is respectfully submitted that the applicants, in respect of their attacks on the confession, admissibility by conduct, and the circumstantial evidence, have failed to show on the balance of probabilities that they will be acquitted of the charges they face. It is therefore respectfully submitted that the applicant's attack on the state case does not provide them with the required exceptional circumstances. Insofar as the present conditions consent. Should the applicants not be satisfied with the conditions they find themselves in, they should have various legal remedies available to them, as stated in State v. Van Veek 2005-1, CCR 41, SCA at 45H. In conclusion, it is ultimately respectfully submitted that the applicants have failed to show the presence of the required exceptional circumstances. The State, therefore, respectfully submitted that the application for the release of the applicants on bail pending finalization of their trial should be dismissed. As far as the applicable law is concerned, Section 35 of the Constitution of the Republic, that is Act 108 of 1996, on arrested, detained, and accused persons, Section 35(1) states, everyone who is arrested for allegedly committing an offense has the right, at his first court appearance, after being arrested, to be charged or to be informed of the reason for his detention, to continue, or to be released. F, to be released from detention if the interests of justice permit, subject to reasonable conditions. Section 60(11) of the Act, that is Act 51 of 1977, the Criminal Procedure Act, states, notwithstanding any provisions of this Act where an accused is charged with an offense referred to in A, that is Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his or her release. In State v. Matebula, 2010, 1 SACR 55 SCA, where the appellant was arrested on charges of murder and possession of arms and ammunition, since the main charge formed part of the category of the offences in Schedule 6 to the Criminal Procedure Act 51 of 1977, the appellant undertook the task of adducing evidence to satisfy the court that the exceptional circumstances existed which in the interest of justice permit his release on bail by way of an affidavit. It was held that the appellant relied upon affidavit evidence which was not open to test by cross-examination and therefore less persuasive. It was held further that to successfully challenge the merits of the state case in bail proceedings, the applicant must prove on a balance of probabilities that he will be acquitted of the charge. Until the applicant had set up a prima facie case, the prosecution failing, there was no call on the state to rebut his evidence to that effect, that the appellant had not contributed anything to establish the existence of exceptional circumstances. Furthermore, that the parroting of the terms of Section 60 sub 4 did not establish any of the grounds without the addition of the facts that added weight to the appellant's ipse dixit. Resultantly, the appeal accordingly was dismissed. In reverting back to this application, the applicants, each of them, claimed that they were assaulted, threatened, tortured to make confessions and point out certain things. It is submitted by the applicant's legal representative that it is permissible to refer to the confession and point out and argue why is that admissible at this stage. The reference being made to the matter of Mahlangu and another versus Minister of Police, 2020, Volume 2, SACR 136, the Supreme Court of Appeal decision, where it was held on probability had the plaintiffs in this matter applied for bail. The magistrate hearing the bail application, just like a judge in the trial court, would have had no difficulty in concluding that the confession was inadmissible. However, this court wishes to state that there are sharp differences between Mahlangu's matter and the matter or the bail application this court is seized with. There's no common cause in this bail application that the applicants were assaulted, tortured, unlike in the Mahlangu matter, where there was common cause, or this was common cause. Therefore, this court is not going to make any finding that the confessions or pointing outs are inadmissible. The admissibility or not of the confessions and the pointing outs will be determined by the trial court. As to whether the applicants were denied their right to legal representation or access to their legal representative, this aspect is also in dispute and has a bearing on the admissibility or not of the confessions and pointing outs. Resultantly, this court is also not going to make any finding on this aspect, for it will be determined by the trial court. In his supplementary affidavit and on argument by the applicant's advocate, it was stated that the unequivocal denial by Zweli Mkhize of the contents of the confession by the first applicant relating to Zweli Mkhize's involvement in the crime, together with at least the explanation as to the improbability of his connection with the offense, affords further basis for a finding, even that at this early stage, and moreover, at the hearing of the bail application, that the confession of the first applicant, at least in this material respect, is palpably false. The advocate arguing furthermore that Zweli Mkhize's press statement, as per the Daily Maverick, as per Annexure SS1, should be given weight. This court wishes to state that the legal representatives of the applicants are misdirected on this aspect. Their argument cannot be upheld in that Zweli Mkhize's press statement was not made under oath. It is a mere press statement with no evidential weight, and therefore this court is not going to attach any weight to such press statement. Furthermore, the court is not going to make a finding that applicant's one's confession is false. Applicant 1 to 6 face serious offenses. If convicted, they might be sent to prison for a very, very long time. This might necessitate the applicants not standing their trial if released on bail. All 6 applicants, either by confessions or point outs at this stage, are linked to the murder of Babita Deokaran until such time that the trial court makes a finding on the admissibility or not of such confessions and pointing outs. Applicant number 1, Pakamani Hadebe, was arrested on the 26th of August 2021 at approximately 1940 minutes in Rosettenville whilst driving and being the only occupant of a Volkswagen Polo with registration numbers CV H2BJGP, which vehicle was used in the planning and execution of the murder. Pakamani Hadebe, shortly after his arrest, made a confession in respect of the events of the 23rd of August 2021, as well as the days leading up to the incident, to the Justice of Peace, a captain in the South African Police Service, which included details of all his co-accused or applicants, as well as the identity of the persons who ordered the murder of the deceased. On the afternoon of the 23rd of August 2021, Captain Park Zita Hadebe, along with a suspect yet to be arrested, was seen in possession of a white BMW with the same distinctive features that was seen following the deceased vehicle and seen fleeing the vicinity of the scene of the offense. Zita Hadebe, together with Ndlovu, Mbele and Dladla, gave their residential addresses as 32 Victoria Street, Rosettenville. The others verified with one Mrs. Unke, who indicated that all 4 applicants have resided at the premises for only 3 weeks prior to their arrest. Zita Hadebe, prior to the 3 weeks, resident in Rosettenville, comes from KwaZulu-Natal from an unknown address. Zita Hadebe is also sought by the police in respect of Linden, CAS 227 of 6 of 2015, and Captain Park, CAS 336 of 6 of 2015. Applicant 3, Ndlovu, was arrested at number 32 Victoria Street, Rosettenville on the 26th of August 2021. After his address, Ndlovu made a pointing out to Lieutenant Colonel of the South African Police Service, wherein he admitted his involvement in the murder. The residential address provided, number 32 Victoria Street, was occupied by him and others for only 3 weeks prior to their arrest. Before the 3 weeks period, he came from KwaZulu-Natal from an unknown address. A bench warrant of arrest was issued for Ndlovu on the 15th of June 2021 at Alexandra Regional Court for failure to appear before court in respect of Regional Court 310/2021, which raised to the charge of possession of a licensed firearm. And not only did he not appear before court in this matter, and this court rejects his explanation as to failure to appear before court on those two occasions, in that it's unconvincing and appears to be false or untrue. Applicant number 4, Sanele Mbele, was arrested in the bathroom at 32 Victoria Street, Rosettenville, on the evening of the 26th of August 2021. He later made a pointing out and confession regarding his involvement in the murder. He provided his residential address as 32 Victoria Road, Rosettenville, a residential address he occupied for 3 weeks prior to his arrest. Sanele Mbele comes from KwaZulu-Natal from an unknown address. Applicant number 5, Sipho Mazibuko, was arrested on the 26th of August 2021 at approximately 20:45 while driving his Volkswagen Polo with registration numbers HV49JKGP. It has been established that a photo of the residential complex that the deceased resided was saved in his mobile phone. Upon his arrest, and having been warned of his rights, Sipho Mazibuko confessed of his involvement in the offense. However, at a later stage, when formally booked out for his statement to be reduced to writing, he stated that he has consulted with his attorney, who told him not to say anything further. Applicant number 6, Sipakanyiswa Dladla, was arrested on the evening of the 26th of August 2021 at number 32 Victoria Street, Rosettenville. After his arrest, Sipakanyiswa Dladla made a point out and confession in respect of his involvement in the murder of the deceased. A J50 warrant of arrest was issued for Sipakanyiswa Dladla in respect of a murder and robbery that occurred on the 11th of May 2019 in Escort. He gave his address as number 32 Victoria Street, Rosettenville, an address he occupied for 3 weeks prior to his arrest. He comes from KwaZulu-Natal from an unknown address. Coming from KwaZulu-Natal, where there's no street name or number, referred to by the investigating officer as an unknown address. With those that come from those areas, and the applicants stated, are released on bail, possibilities are that they might not be able to be traced if they do not come back and appear before court. Interests of justice do not permit their release on bail. From the above, it is abundantly clear that the interests of justice do not permit the release of the applicants, that is 1 to 6 on bail. They all are linked to the charges preferred against them. Either murder, conspiracy to commit murder, possession of a licensed firearm, taking into account, of course, the doctrine of common purpose. other than vehemently challenging the admissibility or not of the confessions and point outs made by the applicants. There's nothing exceptional that the applicants have placed before this court. Applicants have failed dismally so to prove on the balance or preponderance of probabilities that exceptional circumstances exist which in the interest of justice permit their release on bail. And in the circumstances, the following order is made. Applicants 1, 2, 3, 4, 5 and 6 application to be released on bail is dismissed. I thank you.
Your Worship, we have ruled upon a date of the 24th of February for further investigation back to court number 23. 24 February 2022 in court number 23.
kanti ke futhi ke idrada lezi azimamagama mapho-ke inkosi enkantolo ithi-ke iyabona ukuthi uma ngase-ke ngithiwa ngiyakhululwa ngebheli, lokho kuzokwenza ukuthi ningatholakali kalula ngoba nakho-ke ama-address awekho-ke. Manje-ke inkosi enkantolo ithi mina-ke futhi anibekanga-ke isimo esikhethekile phambi kwayo, ingakho-ke namuhla ibonela ukuthi-ke isicelo senu sebheli senqatshiwe. Kuthiwa-ke ummangalelo wokuqala, owesibili, owesithathu, owesine, owesihlanu kanye-ke nommangalelo wesithupha nonke linqatshelwe ibheli kule court yanamhlanje.
Will I confirm the date as well as the reason for the operation being long for the investigation?
Thank you, sir. This matter is remanded to the 24th of February 2022. Further investigations. Original Court 23, which is 1 to 6, are in custody. No bail fixed for all 6 of you.
Court number 23, on Friday 24 February 2022. This will be
as well. But at this stage, then the court is going to adjourn for